Good morning. Thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled CFPB Update, Chopra's First 6 Months. My name is Ori Lev, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of our Financial Services Regulatory and Enforcement Practice. I represent financial institutions and other companies in government enforcement matters, internal investigations and litigation, and provide regulatory advice and counsel on federal consumer financial and economic sanctions law. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded, and we will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com, and we will respond promptly. This is the same email address on your invitation email. Joining me today is Mayor Brown partner Stephanie Robinson. Stephanie is also a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. She focuses her practice on a range of matters related to mortgage banking and consumer finance in both the primary and secondary markets. Stephanie represents banks, mortgage lenders and servicers, and consumer finance companies in enforcement proceedings before U.S. federal and state agencies. She also counsels clients on compliance matters involving a variety of issues relating to mortgage lending, servicing, and other consumer lending issues. So to begin our program, we're going to start talking about one of the new tools the CFPB has been using under Director Rohit Chopra. While at the Federal Trade Commission, where he served as a commissioner before taking over as director of the CFPB, Mr. Chopra frequently wrote and spoke about how that agency should use all of the various tools that Congress gave it, many of which had laid fallow for years. At the FTC, that effort was largely about uncovering and using sources of authority that gave the FTC greater remedial authority than its standard UDAP authority provided. Chopra does not need to search for such additional remedial authority at the CFPB, where the Dodd-Frank Act expressly provides for a wide range of remedies and enforcement actions. But he's imported the same approach of scouring the statutes for agency tools that have not been used and has been successful doing so. In the first few months in office, the CFPB has invigorated a previously unused tool for market monitoring. Section 1022 of the Dodd-Frank Act authorizes the CFPB to require covered persons and service providers participating in consumer financial services markets to produce certain information to the Bureau, quote, as necessary for the Bureau to fulfill the monitoring, assessment, and reporting responsibilities imposed by Congress, end quote. The precise scope of this authority has not been tested because it has not been previously widely used by the CFPB. But Chopra is changing that. In October, shortly after he took office, the CFPB issued 1022 orders to 5 big tech companies, asking them to provide the Bureau with extensive information about those companies' payment systems. The companies include the biggest names in the tech world: Amazon, Apple, Facebook, Google, PayPal, and Square. The orders themselves were remarkably intrusive, seeking information not only about the company's business practices, but also about proposed plans that were never adopted. A few months later, the CFPB issued a new set of 1022 orders to 5 participants in the burgeoning buy now, pay later market, seeking data and information about their business operations. It remains to be seen whether the CFPB will use this information simply to inform its understanding of the markets or its rulemaking agenda, as the statute contemplates, or to feed its enforcement pipeline. Using 1022 orders affords the CFPB some advantages over traditional enforcement investigations. First, there's no underlying predicate potential legal violation required for issuing such an order. By contrast, an enforcement investigation is supposed to be about ascertaining whether a particular legal violation occurred. Second, unlike enforcement CIDs, which are non-public given the potential stigma of being identified as an enforcement target, there is no statutory or regulatory prohibition on the CFPB publicizing the issuance of 1022 orders as it has done. Using these orders, therefore, allows the CFPB to make a big public splash immediately, showcasing its work, as opposed to having to wait to the end of an enforcement investigation, which can take several years before the CFPB's activity becomes public. We expect continued use of these orders over the coming years now that the CFPB has uncovered this tool. With that, I'm going to turn it over to Stephanie to talk about some policy issues.
Yeah, thanks, Ori. And I'll just touch on a couple of policy issues that have been a real focal point under Director Chopra so far. One is that the CFPB has really ratcheted up its criticism of consumer reporting agencies over the last 6 months. They've issued a number of pieces on the failure of nationwide consumer reporting agencies to respond substantively and appropriately to consumer complaints. So just last month, the Bureau released a report that criticized what Chopra is referring to as America's credit reporting oligopoly for some harm stemming from what he's calling their faulty financial surveillance business model. And that report shows that complaints about the nationwide CRAs actually accounted for more than half of all the complaints received by the CFPB in the years 2020 and 2021. And they attribute that partly to consumers that are submitting multiple complaints in a single session. They're submitting complaints against each of the 3 credit bureaus at one time, and also because there are more third parties that are acting as agents submitting complaints on behalf of consumers. So all of that contributes to the volume of complaints about the CRAs, but the Bureau was very critical in its report of the kind of form letters that CRAs were sending to consumers and the responses saying that the CRA wouldn't take any further action when they suspected that the complaint had been submitted by a third party without the consumer's authorization. Aside from that report, the Bureau had also issued a warning bulletin in January about the No Surprises Act. So this bulletin is intended to remind debt collectors that the FDCPA prohibits misrepresentations, and that would include misrepresenting that the consumer has to pay a debt stemming from a charge that exceeds the amount permitted by the new federal No Surprises Act. And the bulletin also reminds furnishers and CRAs that the FCRA's accuracy and dispute obligations apply with respect to debt that stems from charges exceeding the federal No Surprises Act. And then finally, they also released recently an annual list of consumer reporting companies, again referring to them as surveillance companies, and actually encouraging consumers to sue them if they violate the Fair Credit Reporting Act. And this kind of rhetoric from Director Chopra about CRAs has been pretty consistent throughout the 6-month tenure at the Bureau, and even before that from its time at the FTC. So I think clearly we can expect to see a continuing spotlight on CRAs. Secondly, another big area of focus for Director Chopra is student loan debt. On January 20th, the Bureau announced that it's going to start examining the in-house lending operations of colleges and universities. So, they already do have an exam module for education loans, but what they've done is added some specific questions to this kind of institutional lending. They appear to be most concerned about the power imbalance between students and the educational institutions that they attend and the potential consequences of those imbalances. So the new exam module will review institutional lending for practices like withholding transcripts or imposing restrictions on enrolling in classes just because a borrower is late on their loan payments. Some of the other practices the Bureau specifically called out are using acceleration clauses in loans when a student withdraws from the program, or failing to issue refunds when a student withdraws if they're entitled to a refund. The Bureau's press release about this also warns that schools that have preferential relationships with certain lenders could become subject to additional scrutiny if the students end up paying more for their loans as a result. So we would expect that the Bureau is going to be scrutinizing schools' collection efforts, in particular for potential violation with UDAP prohibitions in Dodd-Frank and FDCPA. With that, Ori, I'll turn it back to you to cover EWA.
Thanks, Stephanie. So we've previously spoken about how one of the legacies of Kathy Kraninger's tenure as CFPB director was the invigoration of the agency's innovation initiatives. She revitalized the No Action Letter program and launched an advisory opinion program, and we wondered whether this would continue under Director Chopra. The early signs are not promising. Shortly after taking office, Director Chopra received a letter from a number of consumer groups urging the CFPB to withdraw an advisory opinion that it had issued about earned wage access products. Earned wage access products generally allow consumers to access the wages they've already earned before their official payday. And the CFPB's advisory opinion had concluded that earned wage access products that meet certain criteria, including that the employee makes no payment for access to her earned wages, do not qualify as credit under the Truth in Lending Act and Regulation Z. Last month, the CFPB's acting general counsel, who had been appointed by Director Chopra, sent a letter to some of those consumer groups noting that the advisory opinion had caused, quote, significant confusion in the marketplace, end quote, and that he was going to recommend to Director Chopra that the CFPB consider how to provide greater clarity on these types of issues. As of now, the advisory opinion has not been rescinded, and no other changes have been made to the advisory opinion program generally. But we view the acting general counsel's letter as a signal that Director Chopra may be less amenable to these innovation initiatives than Director Kraninger was during her tenure. With that, we're going to turn to enforcement. And the CFPB's first enforcement actor under Director Chopra was against a non-bank company called JPay. JPay provides debit cards to individuals upon their release from incarceration, and the cards can contain commissary funds of the individual or what's known as gate money, which are various funds that are provided by the government to help an individual transition upon release from incarceration. The consent order focused on fees that JPay charged consumers to use those cards. And first, the CFPB alleged that JPay violated the Electronic Funds Transfer Act and its implementing Regulation E by requiring consumers to establish an account with the institution that issued the debit cards in order to obtain gate money, which is a government benefit. You can't condition the receipt of benefits on that. And the CFPB also found that the company engaged in unfair practices by charging fees that weren't authorized by the cardholder agreement that was given to the consumers, and engaged in deceptive practices by misrepresenting the applicable fees in the cardholder agreement and in the fee summary. And those latter claims are rather straightforward and ordinary kinds of UDAP claims that we would typically see. But what made the JPay settlement notable was that the CFPB also brought an unfairness and abusiveness claim against the company based on its charging of any fees, even those that were properly disclosed, because consumers had no choice but to receive these funds on the cards, and they had no way to access the funds without paying a fee. And the CFPB alleged that this was an unfair practice because it caused consumers harm, the fees they paid were the harm, and that they couldn't reasonably avoid it given the lack of alternatives. That, too, is not necessarily novel, but the CFPB also said that the charging of these fees was an abusive practice because it took unreasonable advantage of the consumer's inability to protect their interests, which is one of the four definitions of abusive conduct. And in making that abusiveness claim, the CFPB alleged that JPay entered into contract with these local corrections departments and that those contracts enabled the corrections departments to eliminate cash and check options for the disbursement of funds, thus advancing JPay's market position. And that it was this conduct of using its market position to its benefit that constituted taking unreasonable advantage of the consumer's inability to protect their interests. And we're going to talk a little bit more about this later in the call, but in a separate statement, Director Chopra characterized this as JPay, quote, abusing its market power by negotiating these contracts where it was the only option, and that abuse of market power is what constituted the predicate taking unreasonable advantage that's required for an abusiveness finding, which is a decidedly antitrust-focused approach to abusiveness that we have not seen before. It's pretty clear that the investigation into JPay preceded Chopra's arrival at the CFPB. These things take a while. It's so I think the case was probably ripe for decision when he arrived. But the precise nature of the abusiveness claim with its focus on abusing market power and the agency's rhetoric around it appear to have clearly been shaped by Director Chopra. And speaking of rhetoric and enforcement cases, the CFPB also settled the lawsuit it had brought against LendUp, which is a company that offered single payment installment loans to consumers. And this is a company that had previously been subject to 2 CFPB enforcement actions. The new lawsuit accused LendUp of deceptively marketing its loans and of violating the prior consent order against it. And the settlement with the CFPB prohibits LendUp from making any new loans and collecting on certain outstanding debt and imposes a $100,000 civil money penalty on the company. But perhaps the most notable thing about this was the CFPB's rhetoric in announcing the settlement. Although the claims in the complaint had nothing to do with the investors who funded LendUp, the CFPB press release announcing the settlement was captioned, quote, CFPB shutters lending by VC-backed fintech for violating agency orders. And then it goes on to list by name the prominent venture capital firms that have invested in the company. And similarly, the Director Chopra's quote in the press release starts off by noting that, quote, LendUp was backed by some of the biggest names in venture capital. And we expect to see a continuation of such rhetoric in CFPB enforcement announcements in the coming years, reminiscent of the rhetoric that accompanied such announcements under Director Chopra. And I will turn it back to Stephanie to talk about yet another enforcement action.
Yeah, I'll just cover one more enforcement action since we're on the topic of rhetoric in enforcement actions and settlements. And here's one that also clearly preceded Chopra's arrival at the CFPB. It's the Trustmark settlement, which the CFPB announced back in October. It's a fair lending settlement, which was the result of an OCC exam of a bank's lending activity back in 2014 through 2016. And the OCC had referred the matter to the Department of Justice and CFPB for investigation because they found a pattern or practice of discrimination in violation of the Fair Housing Act. It's a redlining matter, so the allegations in Trustmark were that the bank allegedly redlined predominantly Black and Hispanic neighborhoods in the Memphis, Tennessee area. And so they reached a settlement back in October. All 3 agencies announced it on the same day, and each agency had its own take on the settlement. And what's interesting to me is that the CFPB's announcement was by far the harshest of the 3, characterizing the bank's violations as deliberate, with Director Chopra stating that the bank purposely excluded and discriminated against Black and Hispanic communities. And then what's also interesting is that although apparently totally unrelated to the settlements and the underlying allegations, Director Chopra also used the press release as an opportunity to return to a topic that he's raised many times before, which is that of algorithmic bias. In the press release, he said the federal government will be working to rid the market of racist business practices, including those by discriminatory algorithms. And that's kind of a non sequitur, and incidentally, it's not the only time the Bureau has made a reference like this. Even just last month, there was a blog post by the Assistant Director for the Office of Supervision Policy, and that was talking about some things that the Bureau had found through supervisory examinations. And again, totally out of context, she referenced algorithmic bias and threatened consequences for what she was referring to as robo-discrimination. So I think in basically all fair lending contexts, we're going to keep hearing references to algorithmic bias, and the CFPB under Director Chopra is going to be looking for more opportunities to talk about that. But anyway, going back to the Trustmark settlement, the DOJ's press release was most notable for announcing the launch of a new initiative focusing on redlining. And the DOJ also noted its intention to increase coordination with state AGs on potential fair lending violations. And I mention that because this idea of coordination across agencies is kind of interesting, and we're hearing more and more about that. And Director Chopra has also said recently that he wants to increase coordination with state AGs. So, despite, well, let me just go back a second. So I want to talk about this December meeting of the National Association of Attorneys General that Director Chopra attended and spoke at. And he made some remarks there in which he was really trying to engage with the AGs and trying to get them to work more with the Bureau and coordinate more with the Bureau, while at the same time distancing the Bureau from the OCC. So despite the fact that the Bureau had coordinated the Trustmark settlement with the OCC, he was extremely critical of the OCC when he made remarks at this NAG meeting in December. He essentially accused OCC of actively undermining the work of state AGs, and he kind of implied that the OCC's preemption rules effectively caused the subprime mortgage crisis. So in differentiating the Bureau from the OCC, Chopra said the Bureau is going to be taking steps to promote enforcement of federal law by state AGs. And by that, he's referring to Section 1042 of the Dodd-Frank Act, which gave states the power to enforce the Dodd-Frank Act's prohibition on unfair, deceptive, and abusive acts and practices. And, a number of states have already, over the last 10 years or so, taken advantage of that authority. The only limiter is that the states have to give notice to the Bureau prior to filing a complaint. And Chopra said he's really looking at ways to encourage more state enforcement of federal consumer protection laws. He kind of dangled the CFPB's Victims Relief Fund in front of the states as an enticement. This is a fund that currently has a balance of over $400 million that the Bureau hasn't distributed to victims in other matters where it's received civil money penalties. And so Director Chopra suggested that the CFPB might be able to make some of those funds available in state enforcement actions, even where CFPB doesn't join in on the action. Turning to a different topic now, on the sort of rulemaking, I guess, developments. Last week, the CFPB announced a new process that's going to allow the public to submit petitions for rulemaking directly to the Bureau. So there's a provision of the Administrative Procedure Act, Section 553E, which requires federal agencies to give interested parties the right to petition the agency to issue or amend or repeal a rule. Not that many agencies have official procedures in place for accepting and responding to these types of 553E petitions. They're often made behind the scenes by lawyers and lobbyists. But the Bureau has announced that this new process is now available. And interestingly, the Bureau has launched this petitions webpage, and it shows 3 petitions that the Bureau received between November 2018 and January 2019. And it appears that the Bureau took anywhere from 18 months to 2 years to respond to these petitions. So it's unclear what the timeline is going to be for responding to petitions from the public. And the APA says very little about what the requirements are around petitions, but it does seem to require that agencies respond to petitions within a reasonable time. So I'll be interested to see whether the public nature of this process prompts the Bureau to respond meaningfully to each petition in a more timely manner than 2 years. So the announcement indicates that members of the public can reach out directly. There's an email account or various other ways to reach the Bureau to ask for rule changes. And these petitions, as I said, are going to be posted publicly for review and comment. I think, Ori, I'm going to turn it back to you to touch on a couple more things if we have a little bit more time.
Yeah, thanks, Stephanie. 2 last points. One is just the description of one of the more unusual things that happened during Chopra's short tenure to date. And that really related to his role as a director on the FDIC board, where he serves by virtue of his role as CFPB director. In December, the CFPB posted on its website a statement that the FDIC's board had voted to launch a review of the FDIC's Bank Merger Act policies and inviting the public to weigh in and through a request for information that was purportedly issued by the FDIC. Somewhat shockingly, the FDIC then issued its own statement disavowing this request for information and stating that no such document had been approved by the FDIC. And what followed after that was several days of back and forth between the FDIC, which at the time was chaired by Trump appointee Yelena McWilliams, and Director Chopra over what the FDIC had or had not properly decided and various FDIC governance issues. The dispute ultimately boiled down to a question of whether of the power of the FDIC chair, and in this case, she was the sole Republican on the FDIC board and was outnumbered by 3 Democrats. And the question was whether she had the authority to set the agency's agenda, notwithstanding the views of the majority of the board members. After a week or so, the dispute finally ended with Chair McWilliams stepping down from her role at the FDIC. So Chopra and his fellow Democratic directors of the FDIC won this battle. I have to say that in my quarter century in Washington, I can't quite recall a similar interagency battle playing out so publicly. Whatever you might think of the merits of the dispute, it's pretty clear that Chopra was willing to leverage whatever powers he had to bring this issue to a head. And then the last thing we want to comment on is just to make note of one of an interesting thing about the first 6 months of Rohit Chopra's tenure, and that is the extent to which antitrust principles appear to be animating him. The CFPB, of course, doesn't have any antitrust regulatory or enforcement authority. That's authority that's reserved to the Department of Justice and Chopra's former employer, the Federal Trade Commission. But Chopra appears to have been influenced by his time as an FTC commissioner because many of his and the CFPB's public statements since he's taken over as director have had a distinctively antitrust flavor. Some examples include the JPay enforcement action that we discussed earlier, where, as I mentioned, Chopra issued a separate statement that emphasized how JPay had allegedly, quote, abused its market power created by single-source government contracts for prepaid cards. Other examples are Director Chopra's statement accompanying the Bureau's Section 1022 order to payment companies, where he talked about the, quote, tremendous scale and market power that payment businesses have and how that power can pose risks to consumers and to fair competition. And we expect this antitrust-colored approach to consumer protection to continue to animate the CFPB's approach to exercising its authorities, including its UDAP authority in general and its abusiveness authority in particular, and will continue to report on whether that leads to additional novel interpretations of abusiveness or unfairness. And that's it for today. Thank you to our audience for tuning in. A few brief reminders. You'll receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. And lastly, as mentioned before, if you have any questions relating to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.